A very good evening to all of you. I would like to extend a warm welcome to all of you to this Law University Vice-Chancellor's Colloquium on the future of legal education during and after COVID-19. As we enter one of the most unprecedented crises of our times, the largest price paid is human lives. Beyond the human cost, this pandemic has resulted in greater demand for justice. In these times, legal education is perhaps one of the most public policy tools available to produce knowledge, create awareness of rights and freedoms, impart skills, and inspire minds which can contribute to the establishment of a society based on the rule of law that will also promote access to justice. However, with nations going into lockdowns, it also becomes difficult to create an environment for ensuring that access to justice. Law school, amongst others, have had to be temporarily suspended, including classes being suspended. Learning for the safety of their students, faculty and staff have indeed been impacted. Many law schools in India and around the world have been faced with a considerable challenge to very quickly evolve into e-classrooms to ensure academic continuity. But we also know that this is a luxury of the privileged. There are numerous institutions in our country, among the 1,600 law schools, where this is simply unimaginable. Keeping this in mind, a lot of questions about the future of legal education during and after COVID-19 need to be addressed, right from the required evolution of curriculum and faculty to building student engagement with the constraints of e-learning, internships, moot courts, legal aid clinics, bar exams, including future jobs, as well as professional opportunities for our students. Therefore, this colloquium is an important platform for us to come together to build collective consciousness to promote the future of legal education. I have a fantastic set of individuals, change makers, institution builders, and law professors and vice chancellors who have joined us today. Let me invite and introduce Dr. Sudhir Krishnaswamy. He's an Indian academic, administrator, and civil society activist who is currently the vice chancellor of the National Law School of India, University, Bangalore, a distinguished alumnus of that institution. He's also the founder of the not-for-profit Research Trust Center for Law and Policy Research. Recently, Facebook appointed him to be Content Oversight Board. In the past, Dr. Sudhir has also worked in the Prime Minister's Committee on Infrastructure and the Kasturi Rangan Committee on Governance of Bangalore. Professor Dr. Vijay Kumar is presently the Vice Chancellor of National Law School, National Law Institute University, Bhopal, and is also the former Vice Chancellor of Dr. Ambedkar Law University, one of the founding faculty members of the National Law School, Bangalore as well. He's also serving as the president on CLAT Consortium and is in the board of several national law schools, hearing various policy issues. He held the SPR chair on refugee law and also has been recognized by the Indian Red Cross Society, presented the Best Vice Chancellor Award in 2011 and 12. We have Professor Dr. Kamala Shankaran, a distinguished law academic, former Vice Chancellor of the Tamil Nadu National Law University in Trichy. He served as a member of the working group on migration, set up in the Ministry of Housing and Urban Poverty Alleviation, Government of India, and also on the Delhi High Court Legal Service Committee and the Delhi State Legal Services Committee. We have with us Dr. Poonam Saxena, another eminent distinguished professor of law and currently the Vice Chancellor of National Law University, Jodhpur, a prolific writer, a thoughtful researcher, serves in the editorial board of a number of national and international journals, including the National Capital Law. She has also been awarded the prestigious Senior Fulbright Fellowship in 1998 and the Shastri Indo-Canadian Fellowship in 2000. We have with us Dr. Professor Ranbir Singh, Vice Chancellor of National Law University, and also the former Vice Chancellor of NASA, who has served with distinction as Vice Chancellor for a very significant period of time. His contribution in redesigning legal education in the country has been significant, being a member of the Legal Education Committee of the Bar Council. The British Council had portrayed him as one of the 12 talented, creative, and generous spirits who are making an effort personally and through their institution to ensure engagement with the UK. Thank you very much, my dear friends and mentors and Vice Chancellors. It's wonderful to have all of you for this discussion. Let me begin by asking the most important question, and that is, this pandemic has changed the face of higher education in numerous ways, including legal education. As we make this transition, how does one overcome the pedagogical differences between physical and e-classrooms? We have, many of us, including all of you, I'm sure, have seen the transition moving from physical education to online education. New imagination towards legal aid clinics and workshops are being presented. How do we ensure continuing framework for experiential learning can be possible even in this time? Let me begin by requesting Professor Ranbir Singh to take on that question. You may have to unmute yourself. Nagendra, can you unmute? So we can't hear you. You have to unmute yourself. Yes, it's okay now. Yes.
Somebody said tomorrow is not going to be the same. And this particular line applies more to the present situation, which we're facing today, which we never imagined, that disruptive forces will change the entire setup of education like this. And I have to flag certain concerns which have immediately come to the forefront for all legal institutions across the country. And you know, we have about 1,600 colleges, we have about 250 law faculties, and then about 24 law universities. And the issues which I want to flag today would be the first casualty would be institutional identity. After great hard work, actually, I will like to share with you, law schools and other institutions, they have created their own place in the field of legal education. And some places are known by best of international faculty they invite, like Global Jindal is known for that. And some institutions are known for best of research we conduct and attract best of funding from best of foundations abroad, like NLU Delhi or other institute law schools are doing, right? And then these forces have certainly not put a full stop, but threatened the very existence of the identity which we created. And we have to reinvent ourselves, that how do we carry on. The next difficulty which we are facing is that we have for a long time, rather all the time, learning by being with the teacher. Now suddenly we find that disconnect, which is very painful, between the teacher and the taught. That disconnect will continue for a long time. And digital learning may be for some time okay, but in a profession like law, the connect between the faculty and the student is very, very important, because there are a lot of activities which cannot be carried on without the connect between the teacher and the student. And there are classroom activities, there are field activities where it is very important. And it is very, that when I say this would mean it is very, very difficult to teach practical subjects. In law, we have practical subjects. We have been doing moots, we have been doing legal aid work, we have been doing clinical courses, and there are a lot of courses which cannot be taught in a atmosphere like this. The digital environment would not have serious answer to many of these things which we have been carrying on. Another difficulty would be the lack of financial resources. When I am seeing a trend in some of the law schools, now the students have started challenging, since we are not coming to the classroom, since we are not staying in the hostels, their expectations have changed. And administratively, we as vice chancellors or deans are going to face different kind of problems. And unfortunately, I came to know that in some of these states, there have been petitions by the students for certain issues that probably since this kind of facility is not being extended, then the pattern of finances to the institution should be different. And you already see that there is a crunch of resources by the UGC or by the HRD or by the state governments, but because somewhere down the line they are giving you a kind of a hint time and again that you learn to manage yourself, and we will not be able to fund the institutions anymore. So the funding is going to be a very, very big problem for all the institutions for times to come. Another difficulty which I see is, and I'm worried about this, is the effect on the mobility of the faculty. Like your institution would be facing that difficulty more than us, because you have been attracting a lot of faculty from abroad. The best of people from different law schools have been coming to Global Jindal, and they've been coming to even NLU Delhi on a GYAN program or as a Fulbright scholars. People would be apprehensive in traveling and staying in jurisdictions outside their own countries. So that mobility, which will we put at a halt, would again create difficulty in terms of how do we maintain standards in the education and research when that kind of interface between the local and the global faculty is gone. There would be, of course, effect on.
Thank you very much, sir, for that. We will come back to some of those issues that you have raised. I would like to quickly go to Professor Kamala Shankaran. Professor Shankaran, one of the things that has happened in the course of COVID-19 is that some of the very fundamental aspects that have been bothering our society's ability to create a culture for respect for the rule of law has come to the forefront more strongly. In some ways, COVID-19 did not stop the continuing challenge of issues relating to discrimination, including aspects such as domestic violence, including child abuse. These issues have come to the forefront. So the question that I have for you is that, to what extent legal education that we provide for our students should have a stronger imagination for these issues, not only during ordinary times, but even during extraordinary times that we are living?
I think legal education, remember, produces tomorrow's judges, it produces tomorrow's lawyers, it produces a variety of officers and people in important positions, and in one sense, decision makers across the spectrum. Now, our legal education, and I'm now referring broadly because I have an experience both of 5-year law schools and 3-year law schools, have had different variety of approaches on how to address social justice in the classroom, social justice in the curriculum, and to create a more sensitive citizen for tomorrow. Because if law and if legal education does not take the rule of law education very seriously, I don't think any other discipline will. Now, in these COVID-19 times, when we are moving into an online and digital classroom, so I think I'll focus on that a little more than just a broader question. You see both a plus and a minus. You see that it has the ability to draw a large number of people into a virtual classroom, not necessarily as students of a law university, but broadly speaking also. And in that sense, that width of access seems to be a welcome thing, because you are able to get people at perhaps a fraction of a cost of living on a campus and undergoing the campus experience, but perhaps having access to the best. Okay, so you could have access. So there is a throwing open of access, which I think is a good thing. But then there is also a loss in the sense that interpersonal relationships get. Now, since you asked that question, I'd like to take up one example. Take, for example, sexual harassment, which we are seeing in a great way in many educational institutions. When the Vishaka judgment came out in the late 90s, many of us who were then already in universities and institutions had set up ICCs to deal with sexual harassment. I'll come back to legal education using this as a peg. Now over years, we see that increasingly harassment takes an online form. And we find that the older forms are not quite capable of dealing with this. The teachers and the staff in the ICC are quite unclear how to track harassment that goes online. Now, I'm using this as a metaphor, an example to say, even the means by which we teach and the mode of teaching has to change when we have digital education being imparted. And in COVID times, I mean, if you ask me, the most abiding image of the COVID times is not really the pandemic, but these streams of migrant workers who are going back in a country where legal education is there, where clinics are there, where rights are there, we find that there are a whole number of people in India, in fact, the vast majority, seem to be stripped of the rights. So, what is it that we did right and what is it that we did wrong? I think is a useful starting exercise for this. So, if you give me another minute more, let me just share a couple of ideas with you. That
We will come back
the
with the,
one is the curriculum. Okay, we can come back.
come back
Okay,
to that question as well. And thank you
sure.
very much for what you said regarding migrant workers, and we are planning to revisit that as well. Now I call upon Professor Vijay Kumar. Professor Vijay Kumar, building on what Professor Ranbir Singh and Professor Kamala Shankaran mentioned, the biggest dilemma that is facing law schools today is that this transition from a more physical enabled educational system that we're used to an online educational system that we are somewhat forced to what extent it will, let's say, require a change in our pedagogy, in our curriculum, in our classroom ecosystem, and how do we see this transition moving into the legal profession itself? Meaning, is this going to be a short-term change, or are we looking at a long-term shift and new thinking in this?
Yeah, wonderful. Thank you, Rajkumar. I look at this from two independent formats. One is about during pandemonium, and the other one is immediately after pandemonium. Now, if you look at what is happening at this particular point of time, in the last couple of years, the UGC has been promoting its program called MOOCs, and then we started understanding that even to run these MOOCs, we should have some sort of modest infrastructure on campus, modest bandwidth so that it could be distributed well to all the students, the recipients, and uninterrupted power supply. So I think the infrastructural improvement needs to be done, which I think many of the law schools have already taken that into account. But however, I have my own apprehension to what extent these law schools have stood up to the expectation of the UGC or anybody else in terms of the MOOCs courses, except possibly the National Law University Delhi and also NLS Bangalore to some extent. Many of the law schools are lagging behind, including that of mine, where we are not able to train these teachers because they have been brought in the traditional method of teaching, and their access to what you call it as technology-based teaching and learning possibly needs to be improved to a great extent. This is on one side. On the other side, you also have a number of students coming from rural areas. Though they are too good in operating their mobile phones, I think when it comes to the process of learning, I think there is a lot of collation that is necessary. One is voice, the other one is document, the third one is maybe a video, fourth one may be a PDF or another document. To collect all of them at a particular point of time using a mobile phone may also pose some sort of a problem to the students. Therefore, when you look at it, immediately after this pandemonium struck and the institutions have been closed, we have been trying to use the online methods. And online methods, I think, has been left to every individual teacher. So sometimes I can send a PDF document and keep quiet, ask the students to read and understand everything, or send a Word format or a book or an article, or I can send a PowerPoint presentation with, I don't explain, but these points are there, visible for them. Maybe some video lectures which can possibly do this. Now, all these things have created lots of problems even for the students, and we have received, when we wanted to go on online examination of the students, you have posse of letters coming from the students that we don't have the internet connection, my computer crashed, I have to go out but I cannot go out because of COVID, lots of other issues. So therefore there is a gap between the teacher and the taught as far as the technology, the learning tool itself is concerned. So teaching tool on one side, learning tool on the other, both must be taken together a little more seriously in the months to come so that we are able to do a better job, because COVID is not going to go away, or we cannot wish COVID to go away in the next few months. As the indication comes very clearly, Oxford has done all the online courses up to May 2021. and therefore whether whether they have the information, I don't know. If at all we have to move to the next semester on online, I think many of the law schools must go for series of training. Otherwise, the students will make it very difficult for the institutions to survive, and it will be very difficult for anyone to follow.
Thank you very
And
much, sir. That was a very thoughtful set of responses. I want to quickly move to Professor Poonam Saxena. By the way, for all the viewers, we are on YouTube Live, and please send your questions in. After this round of discussion that I'm having, we will take your questions as well. So, Professor Poonam Saxena, I mean, building on what others have just now said, you see, one of the unique aspects of the idea of a national law school is the idea of a campus environment. The ecosystem of a campus defines the National Law School environment. In fact, if you look at traditional universities such as the one I studied in Faculty of Law campus of Delhi University, while we were living in the hostel, it was not the universal phenomenon. The idea of a national law school the foundations of it is connected to a campus community now, which is temporarily is not there. So my question to you is, as Vice-Chancellor, how do you see this changes the entire landscape of legal education, particularly in national law schools? And what are the short to medium term measures that schools like yours need to take so that we can ensure that there is some semblance of the original vision?
And thank you so much, Professor Rajkumar. First of all, I'll just give me a minute to take on to what Professor Vijay Kumar has said. I think it just came to us all of a sudden, and we were not prepared to it when the lockdown was announced. So all these things we also experienced at NLU Jodhpur, that to begin with, everybody was trying their own way to communicate with the students. Like somebody was doing a PPT, somebody was giving articles, and then we tried for this Zoom, and then there were problems, and then Google, and then finally with Cisco Web. So then we were able to chalk out as timetable, proper timetable. And we realize now that the most important department in any university, is the IT department. If your IT department is good, then you can really take it on. And if the IT department is not really so equipped, then it will be extremely difficult for any national law school to carry it further. So, and then second thing I would like to say is that we do not know when the complete lockdown will be lifted, because the safety of a person is of utmost importance. If the people are not safe, then how will they the education takes a secondary part thereon. So if, as I see it now, we do not know whether we'll be able to start the offline classes or the regular classes or the online mode. But we still have around 2 months, because if we are going to open the classes from August 1st, then we still have time to chalk out an entire plan. Now we are prepared. To begin with, we were not prepared. So I was having a talk with my IT department, and they said we can come up with a proper timetable to not exactly substitute that teaching, but come up with a viable alternative so that the students are not adversely affected. Now coming to the second point, which is extremely important, because it's my firm belief that one of the essential features of the residential schools is the learning from each other. Now, of course, when the students are not on the campus, how to ensure that they learn from each other? Here again, the role of internet and this Zoom and other meetings will be extremely helpful. It's not as if it will totally be eliminated. It will still be there, but it depends upon how we give a shape to it. So we were discussing it with our IT staff, and they said that in each national law schools, there are learning groups and specialized centers. For example, we have a constitutional law society. And till the time the students were on the campus, in the evening, they will be having their regular discussions on some current topic in the mess car or there. Now they can form small groups, Google groups, or come up with Zoom meeting and define and take the help of the institution. The institution will build up the IT support for them to conduct meetings with respect to one particular specialized subjects or a particular case or a particular topic. They can still carry on. The bonding, the kind of bonding that the student used to have on the campus will definitely be not there. But we can come up to some kind of a reasonable alternative with respect to that.
Thank you, ma'am. Thank you so much for that, ma'am. All right. Well, Sudhir, as the youngest and the newest Vice-Chancellor in the group of people among whom we are discussing, can you briefly reflect about this extraordinary reliance on technology that all our panelists are talking about, and juxtapose that with the situation that we are having in our country, where only 8% of our households have pretty much opportunities to use computers and uninterrupted electricity. With this sort of exclusion that we are grappling with, how do institutions respond to it? And equally important is the financial model of law schools that we have today, where the public law schools and the private law schools, to a large extent, particularly the national law schools and private ones like us, we remain fee dependent. And to what extent the fee dependence undermines our own ability to respond to crises of this kind. Sudeep.
Raj, can you hear me? I think
Yes.
you can, yeah.
Yes.
Thanks for the invitation and for organizing this panel. So these are complex questions, and I don't know that short comments do the job, but I will try. Just on the first question of technology, I think that most panelists have reflected that technology platforms are very important, whether they be for the curricular delivery or for the co-curricular delivery. And we might need different platforms for each, and there's a learning process to that. But clearly, we have to think about the layers of technology platforms. I think most law schools are quite comfortable using email, and I think that's been going on for the better part of a decade and a half. But we have not been so good at doing learning management systems. Yeah? Some law schools have developed these and have adapted well to it, using it well. Others have not. Luckily for us at NLS, we took that initiative in September, and we had that layer in place, not perfect, but quite functional. On top of that, you need to put in the online classroom layer, and that too we were able to integrate very quickly. And so luckily for us, we have delivered the entire program, the entire timetable to the dot. So we don't have any disruptions, barring for, I think it was 4 working days. So this can be done, and I think all of us can do it, and we have to learn from each other and deliver. But that is the part that the university can do. But I think the question that you asked me is, what about student access? Now, I don't see the situation as being dire. When we look at growth statistics, and you say that 8% have the quality of connection that might be necessary, that is true. But among the subset of students we educate, I think a good number of them have the capacity. We are not glitch-free in this respect. We have students who have severe access problems, but by and large, we have adapted. I think the key to adaptation is to understand that there can be synchronous and asynchronous learning. If we commit ourselves to synchronous learning all the time, that is that everybody has to be in the class at the same time, then all these constraints of electricity and bandwidth will choke that experience. If we are open to a level of asynchronous learning, learn anytime, engage in different ways, then this opens up the technology problem in a useful way. And given our conditions, I think we have to do that. But I think, as Professor Saxena said, we have to make investments as universities in technology, both in the technology stack that we have on campus, as well as the technological devices and maybe even bandwidth connections. I think some of us have had to subsidize student bandwidth connections. We might well have to think of that as a package. You know, when students join us, they must have a workable device, they must have bandwidth connections. This is almost standard. And if it means that universities, we as universities have to fund that, we have to fund it. Which then takes us to the next question that Raj raised, which is finance. And here, I mean, I'm going to sound a different note to what most of the panelists have said, because my sense is that the threats and the opportunities we have from this crisis, it showed us, I think, what we can do without a very rigorous campus experience. So there's an opportunity there. And what my hunch here is that the on-campus and off-campus learning experience is the distinction between the two is going to slowly whittle away. And this is both a crisis and an opportunity. That means you don't need to be at the top law schools in the world, and you can be educated in India by them. It also means that within India and for us globally, we can have a student community which is widespread, right? We can engage this widespread community. So why am I bringing that up on a question of finance, Raj? Because I think the future is going to be that we educate more students at lower fees.
Thank you so much, Sudhir, for that. I want to take this question to Professor Ranveer Singh, being the most experienced Vice-Chancellor in the panel. Sir, one of the big challenges, what I believe law schools are facing today, law universities including, is that the excessive dependence on the tuition fee by students, but also in some ways the benevolence of the state governments as well. Without naming institutions, it is not an unfair comment to make that state governments have begun to exercise more and more soft and hard forms of control with regard to finance. And that is in many ways affecting and impacting both the vision of a national law institution, but also in relation to the day-to-day governance when it comes to using resources. How do we address this, sir?
I believe, Rajkumar, one very important thing said by Sudhir is that we have to see beyond the law schools now. And as I said earlier, that we have about 1,600 colleges and 250 law faculty. Let us not concentrate whatever problem we discuss about the law schools. We extend our mandate beyond the law schools. And if we spread this digital education platform to the other institutions, and we can certainly generate a lot of resources, because those are the institutions which are looking for good faculty, good resources, good database, good kind of research potential, other activities. So the law schools can be more relevant in terms of reaching out. The foreign countries are doing this, reaching out to those institutions. Like, for example, NLU Delhi created about 700 e-Pathshala lectures. And they are on the free domain platform at the UGC and the HRD. The same way it can be done with a price, and it may not be very costly. So we would be doing a even service to these institutions, those who are in far-flung areas, and those who are, let me share with you, are now, after this COVID-19, are facing a threat of being closed down. You will see that at least 15-20% institutions will be closed down in this country after this COVID-19 situation, because they will not be able to maintain themselves. So this is one area where we can certainly do it. And we have to certainly keep in mind the digital divide in this country. We have to bridge that divide. We have demographic divide. We have also the intellectual divide. And these are the areas where we can step in and create systems and mechanisms where we can also generate resources from.
Thank you so much, Professor Singh. Ma'am, let me move to Dr. Kamala Shankaran. What Professor Ranveer Singh is essentially saying is that, law schools such as the ones which have established a reputation, but also have made significant contributions, they can provide, intellectual and institutional leadership. The fact remains that there is a vast divide in relation to quality of education that gets offered in some law schools as opposed to others in the 1,600 plus law schools. So then the question is, what are the ways by which we could do that? In a way, the biggest challenge that we are facing is what kind of legal education that we can offer to our students that will empower them to address the significant challenges of access to justice that are facing, or to what extent our own notions of elitist education is potentially affecting our ability to achieve that objective, what people would call, what Professor Madhav Menon would call, promoting social values in law and advocacy.
Thank you. I think there are many issues here, and let me take up some of them as quickly as I can. No doubt, access to good materials and access to good teachers can be democratized and made broader. Right. But I don't think that we should narrow the base of knowledge creation and knowledge transmission to just a few elite, because who is to determine that this is the view? We don't want a small and a narrow worldview. Then why India? We could well go abroad and take the best there. So I don't think that that is the only thing. There is a challenge in front of us. Academic leadership can be there, knowledge, content can be given to these 1600 law schools. But there is also a fact that many of these law schools or law colleges are producing lawyers who are going to take up cases in different states, with different languages, with different state laws. Oftentimes, national law schools concentrate on law and legal education pertaining to the central laws and hardly, if ever, to the state laws. So we do need that. So there is a need to unpack the knowledge that is given. So it's a very good thing that some of the law schools have produced this amount of knowledge which can be easily shared. But at the same time, we know that the teaching learning process is never top down. There has to be a creation of knowledge at the bottom. And here I would say language is a very important thing. How do we make this available in different local languages? Number two, that the knowledge itself needs to be relevant. And I go back because we're talking about legal education, that we need to have resources that will be applicable. So land laws in the different states is not being taught in the different national law schools. We need to nuance it further there. And thirdly, when it comes to access, we need to address the issue of course, digital technology makes education cheaper in one sense because it can be given. But that campus experience, and here I think is the toughest challenge, those clinical courses that all the law schools offer. How do we make a format? How do we imaginatively think? And this is a real challenge for all of us who are teachers and administrators, because the training needs to be that using the digital platform, we need to have the ability to skill train students. So it's not only knowledge, it's also skills. And I think it's a bit of both. And we need to have the training sessions, and that should be imaginatively done. So let me just give a couple of examples before I close. One is that I think those of us who have taught using the Google Meet platform or Zoom, I completely agree with what Sudhir said, that synchronous and asynchronous. People who have low digital bandwidth download it at their leisure, but you need occasions where they can come together and they can engage. And in a post-COVID world, I think the learning that we take away is that the classroom is not fixed in those formats of classroom teaching alone, and it's spread out over the whole 24-hour experience. The second thing that I think that we should do is that when we need to have greater engagement and not work in silos, the university with the state universities, how do we engage with them?
Okay, ma'am. Great. Thank you so much for that. Professor Vijay Kumar, we want to take that part, what Professor Kamala Shankaran said, and maybe you can reflect about the fact that, there is a significant dilemma that happens in institutions. At one level, we want to educate young lawyers, law students to become socially conscious and actually contribute to that, vision of legal education. At another level, there is a natural expectation on the part of a large number of young people to be able to, get into private law practice, including working for law firms and corporations and in-house counsel. There's a whole range of imagination surrounding it. So as somebody who has seen through this for decades, what would be the framework of setting the balance within the law schools?
Yeah, it will be very difficult to strike a balance in this because Dr. Sudhir will agree with me. When the law school was started, our intention was that they will go to senior lawyers and practice. But if you just look at the past, these 30 years, the NLS alumni have been all over the world. They have been teachers, they have been researchers, they have been whatnot. They have started their own law firms. I think they have got into a number of aspects which we never thought of. Now, having said that, today we don't want to create somebody who is purely trained in technology and comes out and is not a social animal. A lawyer is supposed to live in the community, understand the problems in the community, find solutions within the community, and therefore whether technology will fix everything, I don't agree with that. And then if that is the case, we'll be only creating zombies who will be just giving some advice here and there over internet, and that's the end of it. But I think as things move forward, I'll just flag one issue: the opportunities for the law students to move around various avenues like cyberspace. For example, the cyber law, the cyber crime, cyber forensics, information security. I think these are the areas which are not purely left to the technology alone. The lawyers have to play a meaningful role, at least 50% of the role, and therefore the lawyers, the law students, even after the pandemonium, will find it very interesting to understand technology, use the technology to their own benefit, and I will be very happy to see that there are many lawyers practicing in various high courts and the Supreme Court who would specialize only in the technology law, not in specific areas of law. And therefore, I see a positive change that's coming in. But to speed up this process, I think the law schools have to do a lot more to make them a wonderful an amalgamation or a harmonious blend of both technology and law, and with some amount of social commitment, without which the lawyer's profession will certainly fail.
Thank you very much, Pastor Vijay Kumar, for that. We have already received over 50 questions, and I will come back to it shortly. Let's move to Professor Poonam Saxena. Professor Saxena, one of the things one of the expectations from among students in law schools is that during their different breaks, both summer and winter, they want to have internships. We believe internships has an important role in the overall growth and development of a law student. And today, due to COVID-19, almost all internships in the physical manner that we're used to has come to a standstill. In fact, this has also had a significant impact on the placement situation. Firms that have given offer to students are either delaying it, sometimes they are withdrawing it. There is again a significant impact in relation to internships and planned placements. How do we respond to this crisis as law schools? But also, can we move some parts of it into an online mode? Is that even feasible?
Thank you, Professor Rajkumar. One of the things that we must note here is that this kind of a situation that we are facing is not permanent in nature, it is temporary. And we have a 5-year law course. So even if one batch of, though the internship and this diluting the break affects everyone, we have been doing it both in online and offline mode, the placement I'm talking about. As far as the internships are concerned, if they are placed with the lawyers or if they are placed with the law firms, then the lawyers and the law firms have to take a call here. We cannot place them with the lawyers and the law firms whose offices are shut virtually. That is very, very true when you say that many of the law firms who had offered jobs, they have either been put on hold or joining dates have been delayed, sometimes indefinitely also, giving us an apprehension that they might be cancelled altogether. So this is, you have very rightly said that this has caused a tremendous stress in the mind of those students, or especially in the final year and who will be passing out, and also the 4th year, because the day zero has been postponed to August, and there is no likelihood that it will take place in the same manner as it used to be done in the past. But having said that, given the fact that it is temporary in character, we do not know when it is going to open, but we are almost certain that it's going to open. And we will come back to the same phase as we were before in a slightly modified form. So what we plan to do is that have the placement committee's discussion. We have had the discussion with the placement committee, and they say many of them are willing to do it online, provided they have a space for jobs. So it can be done online, but many of the law firms are not responding to that request for placement. That is one of the very harsh reality that is going to accost the law students. But I must repeat, it is temporary in character and will come back to the same position, maybe in a year or two.
Thank you very much, ma'am, for that rather optimistic tone, which I believe is critical. Now, let me go to Sudhir. Sudhir, so one of the things that's emerging is, at least in the Indian context, is there is a lot of uncertainty. We have two types of things happening in law schools and universities around the world. One set of institutions, largely in the United States, are braving to open and come to normalcy. And they are talking about testing and treating and tracking, and every student who enters in will be tested and will be tracked down and also treated if he or she has COVID. That's the one end of the spectrum where many universities across the United States have announced it formally. And then you have today's announcement, Cambridge University saying that they will go completely online all the way till 2021. And then Indian institutions are, there is little, regulatory guidance emerging beyond the fact that an announcement has been made that the new students will come in September and the old students can come in August. My question to you as a Vice-Chancellor, but also something which many students will be anxious is, what should be the framework on the basis of which we as law school Vice-Chancellors, law universities, also universities in general, should have in determining our next course of action for the fall term?
Thanks, Raj. The way I would think about the problem is that the position that law schools would take would be local. I can tell you that in Bangalore, the situation doesn't look like how it looks in Delhi or in Bombay. Obviously, none of us have traveled, but what I've heard from colleagues is that Bombay and Delhi are in far worse shape than Bangalore is. So this may change. 1 month later, Bangalore may not be quite so sunny, and then we'll have to respond as we find it. So I suppose the first response is that this is going to be local. It's going to depend on where you're at and what the conditions in these various universities are. But speaking for the general global patterns that you described, whether that be in North America or the UK, I think the first thing we should say is that their experience of the COVID-19 pandemic is far more serious and at far greater scale than anything we have experienced so far. So they are reacting to that intensity of experience. We haven't had an experience quite like that. So we have to respond in a manner that our situation demands. I sense that whether it's August, September, or October, I think the thing that is permanent in my mind is that off-campus and on-campus learning distinctions will slowly dissipate. We have to prepare for the idea that even after we open and things look all right, there is going to be a degree of off-campus learning, including in our core programs. And the way I'm thinking about this is that we have to really think about the scale in which we teach. For me, the on-campus program, anything on campus is a premium program. Anything off campus, we can scale up quite dramatically. We already educate 10,000 people a year. I think we can do 10 times that number in the next few years, and do it well. Do it well. I know that Professor Kamla Shankaran said that it's the engagement that matters, right? There's a social aspect to learning and pedagogy. I completely agree. But technology allows us to bridge that social aspect of learning. And we should embrace that opportunity. So my quick sense is that the minutiae of opening, who opens, we've already put medical screening in. We might need to put testing in, as you described, as we go forward. So we have already anticipated and put some of these processes in. We might need to do more. So that will be a local decision based on local conditions. But the overall trend is very clear. The distinction between on-campus and off-campus is being erased. And I guess the COVID-19 pandemic has hastened that process tremendously.
Thank you very much, Sudhir, for that. Let me move to Professor Ranbir Singh. We are coming close to the end of the first segment of it, and then we move into these 60+ questions which have come. Sir, one of the things that we are facing also on account of COVID, but also the student demands, is that lots of students are thinking about this situation from the standpoint of how it's affecting their ability to have good grades. They are looking at flexible examination and assessment system. Many law schools, I'm sure you have considered that, are giving that type of model, pass-fail approach. Various forms of, let's say, innovative and flexible, adaptable methods of assessment have been infused. On the one hand, that's a necessary intervention, but we also know that the world of job opportunities, including employment, but also many other next steps for law graduates, that's not changing. That remains and will adopt the same standards. So how do law schools such as yours and many others who are in the panel, how should we respond to again strike this delicate balance?
As far as the job opportunities are concerned, these will certainly have a setback initially, but then it will pick up. Other things can be done online, then there is no reason why the placement can't be done online. And my worry would be the biggest challenge for many of the institutions which are residential in character. I fear that we have to lose that residential character in times to come, because the way we are having the students in the hostels now, we will not be able to keep them for a very, very long time. Since the social distancing norms will continue, I don't know, it will be very, very difficult and dangerous to keep students together in the hostels as well as in the mess, or even in the classrooms. So in that situation, I don't know how far we have to be very, very careful in maintaining those social distancing norms probably. Placement, of course, will otherwise also job opportunities are less in such a situation. We are losing jobs on almost all fronts, and legal education is not a exception to that. But I think it will be a short-term challenge, not a long-term challenge.
Thank you very much, sir. Thank you very much. Professor Kamala Shakaran, there's one of the things that we've talked about is about the use of technology. And I think it is in the minds of a lot of young people, but also lawyers, law professors, is that to what extent this assertive approach to embrace technology has the potential to undermine our civil liberties. To what extent issues relating to right to privacy and those concerns need to come to the forefront, because at this point of time, we are in a situation where everything is necessary. We think that everything is necessary to feel safe. For example, the Arogya Setu app, which has been made, let's say, compulsory for in many contexts. Should we be as law professors concerned that we are going too fast and many of these things can become potentially irreversible?
Thank you. Can I just take a step back?
Please.
In terms of digital economy and the world of work, it's often called the fourth industrial revolution. And I think when you come and look at its impact on legal education, it has had a paradigmatic change. And that is that instead of the old assembly line where students went from year to year, class on class, technology allows you to blur those sequencing of classes. It blurs the taking of classes. There's no need for people to be present in the same space and time. And so many paradigms of teaching, that assembly line, the classroom format has changed. Yet I agree with you that it comes with a surveillance mechanism, because we also need to know who is doing what at what time. Now, my experience both at Tamil Nadu National Law University, where we extensively used Google Suite, and well before this pandemic, we were offering classes. Our evaluations were through response papers. I think in the examination system, we need to have regular online examinations. And we also need to ensure that the teacher is engaging with the class. So some amount of surveillance is necessary. If you don't like that bad word, well, we need some levels of checks and balances, because what is the role of the teacher? And we need to protect the role of the teacher. At the same time, there is a loss of privacy, no doubt, when you start monitoring. But I think that comes as part and parcel of older systems of monitoring, where we used to have perhaps attendance and marking of attendance and knowing where people are. Yet as a law school and using these digital technologies, seeing to it that the class and the classroom interaction is not necessarily thrown while, like this program is being carried on YouTube. But why would I want my classroom to be thrown open to the YouTube? I would have the freedom to the student to speak what he or she wants so that her view is kept contained in the classroom. And I go back to what Professor Ranveer Singh was saying about the fact that we are creating these knowledge systems which can be used. Of course, they would be blended, but that is for a wider consumption. So, to go back and specifically answer your question, I think as law teachers, it is our duty that that classroom space, physical or digital, is a safe space. It's a safe space for men and women. People do not use it as a forum for hate speech. That they must be called into account if they were to make statements, because there is some recording that goes on. So that has to be monitored.
Thank you, ma'am.
Teachers' accountability is also there. So I think we must learn how to balance these two things, and it has to be done. We cannot shy away from it.
Thank you very much, ma'am. Professor Vijay Kumar, I want to quickly shift gears a bit and talk to you a little bit about the change in this whole, embracing of technology. We have seen, for example, no less than the Supreme Court of India, Delhi High Court, but also some other high courts have begun to use e-based, let's say, video conferencing, but also other types of platforms to hear cases. That's been happening in more frequent manner. The question then is, we are a vast country. We know that a lot of our access to justice and dispute resolution mechanisms happen in more rural settings. So should we be concerned that the current framework of justice delivery mechanism is creating more divide than the possibility to achieve it? Because the kind of cases that are being heard also reflects that privilege that we talked about before.
Yeah, that's a good question. Before I say something on this,
Please.
I would like to just recall what Dr. Kamala Shankaran said about the privacy issues.
Please.
I just heard a comment yesterday from some of the faculty members in Bhopal that when their lecture was being or looked by the students, the parents were also seeing that and making a comment or passing a comment. Oh, your teacher doesn't know how to pronounce this word. Your teacher doesn't know this. Your teacher doesn't know that. So therefore, I don't know whether it is rooted only to the person who is supposed to be the audience. Generally, someone could just butt in and say that your teacher is not fit to be a teacher. So these are all comments which I think slowly will emerge. Having said that, I would like to just once again, start with what the Chief Justice of India, Justice Bobde, mentioned day before yesterday, that here afterwards the court system will be dual mode. That it is partially online and partially the regular courts. Because till the things improve, you cannot have the type of court system that we have had so far in the last couple of centuries at least. And therefore, social distancing and others, all these are all nice things to speak. But when you go to the court hall and see what's happening, the lawyers falling on each other, the clients falling on each other, I think we need to learn something. Aspect of rural and urban divide, the type of cases that we do look at, I think it will take some time. There is what you call it as the Gram Nyayala Act, which has come into picture long ago, but many states have not taken them seriously. If that is to be picked up usefully, I would rather think that technology can revolutionize judging at the grassroots level in the years to come, and I'll be too happy if the law schools could come together and erect a platform through which the first-hand decisions or first-hand petty cases could be resolved at the local panchayat level. I think there lies what you call it as the contributions of the law schools, and therefore the divide between the urban and the rural could also be minimized. And I don't understand, because today if you look at the use of mobile phones by the rural or the urban, I don't see much of a difference. The technology has played a wonderful role, and it has reached the urban rural area to such an extent we have to only encash that, so that in the judging process the divide between the urban and the rural is also minimized, and the law schools definitely have a role to play in this.
Thank you very much, sir. Let's quickly move to Professor Poonam Saxena. By the way, we've got over 100 plus questions, so I'm going to go there a couple of minutes from now. Professor Saxena, one of the things that we see from what we are hearing is that we know that the access to justice is in a state of crisis, right? We've got evidence to say the 3 crore cases that are pending, and dependency remains a major problem. We also know that we have not been able to develop a strong alternative dispute resolution mechanism. ADR has been one of those work in progress. Do you think that this is an opportunity for India to build a stronger ADR system where a lot of our cases could go through mediation? They don't even come into our regular, trial process. Is it a wake-up call for us to reimagine our justice delivery system, not just having technology, but also reimagining the very framework of ADR?
Professor Rajkumar, on the other hand, I think that in this kind of a situation where social distancing norms and others are taking, even in mediation and conciliation procedures have taken a backseat. As far as the arbitration or the alternate dispute resolution is concerned, it definitely is the need of the hour. But the way we are doing it is not really very encouraging. We need to work very hard on that. As far as arbitration is concerned, as far as failed mediations are concerned, or conciliation proceedings are concerned, it simply add more time to the regular court proceedings, because if the mediation fails, then again you have to go to the court. Conciliation, the alternate dispute mechanism fails. Lok Adalat is of course a different procedure altogether. But as of now, I see that the progress in this direction is going more in the negative way rather than positive, because of the peculiarity of the situation that we are placed in.
Thank you so much, ma'am, for that. Sudhir, so one of the things that we have seen this crisis has also demonstrated is that certain professions, particularly the medical profession, health, have become our designated essential services. Is it time for us to recognize lawyers and judges and their role that they play as essential services? Is access to justice an essential service, and that's why it should remain open and available even during COVID times?
That's a great question, and I'm happy to say that in Karnataka, the police and the Home Department were very quick to authorize lawyers to travel with ID cards. And they treated that as reasonably essential. Our problem was that the courts never opened.
Yeah.
And where would lawyers go to is a question. They might provide some field services, but that's about it. And I want to address that problem of where do courts go. And I think there were several leaders of the bar who said that even in an emergency, in a national emergency, courts must remain open. And this is a very essential public function of the courts. And I think the best we can say for the last 2 months or 3 months has been that some courts have done it better than others, and at best it's erratic. And here is my thought on responding to many of the comments here is I think we have something to learn from the US Supreme Court, which conducted hearings over the last week. Notably, that US Supreme Court proceedings were on telephone. And the telephone proceedings were broadcast to the world. There is a kind of way in which India, we have a kind of technology obsession, but we don't have our courts have been talking about e-courts 1, e-courts 2. I think we are in e-courts 3. And if I'm not mistaken, we're talking about e-courts 4. That's the current policy discussion is at e-courts 4. But really, we can't organize a phone conference. And what's the problem? And maybe we've leapfrogged all of that, and we're now in video conference like we are on this panel. And so in India, we've never had stable landline connections or mobile connections, so we can't rely on phones. I don't know what the problem is. I fear that for all the reasons that we have discussed on this panel, so many of us have responded to the COVID situation in imaginative and responsive ways, being responsible to our students. And I suppose that the courts have an even much greater responsibility than we do, right? To be always open and always accessible. Even if we as educators slip up a little bit, the world might not go crumbling down. But with the courts, there's so much at stake. So my sense is that too much of the court technology discussion has been about leapfrogging and high tech. My own intuition and preference, knowing the courts as many of you do, is to be low tech and highly appropriate technology focused. Really can we crawl before we can run, before we can sprint, and our courts would do very well to crawl.
Thank you very much, Sudhir, for that. So, well, we are now coming to the end of the first segment, and thank you very much for my distinguished guests here. As I said, now we have 250 plus questions, and I'm going to be very selective. Several people, including Satish and Sameer and Chakshu, have all asked one question, and I'm going to take that to Professor Ranveer Singh. You know, the current situation for many aspirants to study law creates a lot of ambiguity, and whether legal profession, does it make sense? What would you respond to those people who are thinking about the future of legal profession during this time?
Future of legal profession is always going to be bright. Let me put it very, very straight. And there will be more and more demand as the sectors of legal education will open. Apart from the fact that the present setback will not continue for a long time, but I'm very sure that even the present challenges will create more jobs for the legal profession. Even online kind of system which will be created in the legal education. You remember Richard Susskind saying, "The death of a lawyer," but the more and more online kind of things will certainly litigation will continue, but we will need different kind of lawyers. So we have to, as you were putting, that we have to constantly reinvent ourselves.
Thank you very much, sir, for that very optimistic and indeed a very futuristic perspective. This question is for Professor Kamala Shankaran. This is from Jayashree and Bala and Sudesh. And the heart of this question is about the problem of access. Here we are, almost all of you in this panel, including myself, we are somewhat privileged in terms of the institutional context that we are in. What is going to happen to those law schools across the country, which are mostly in remote parts of India, the 1600 plus, which we talked about? How does any of the things that we are discussing is going to impact them, and how do we as law schools contribute to provide some impact for their lives?
I think really here all the law schools have to be very, very proactive, because I know that funding is a problem, but without access to a computer, as I see it, for the reasonable foreseeable future, there will be melded education, which is partly offline, partly in class. So we do need phones and we do need laptops. A lot of our focus should focus on giving this kind of infrastructure rather than building enormously large buildings and putting it into capital infrastructure of that sort, which is not portable and which is honestly not usable. You know, I think we should shift our focus away. The era of large buildings, etc., needs to change. And number two, access is an issue, and the state needs to underpin and fund education, whether it's private or whether it's public. You know that the way the international standards are going, and this is an issue for India itself in GATS 4, that there must be no discrimination between private and public. And Article 21 and 19 and the way it's transforming, that the line between private and public education is a narrowing one. And keeping that in mind, I think there must be elements of funding. It need not be 100 versus 0. We have a whole continuum in between. And we need public philanthropy to come in. And without that access, and I think that access is not just the technology of a phone or a laptop, it's also access to library resources which should be given at home. There is a huge monopoly at play, as any Vice-Chancellor knows, Each of us individually have been forking out upwards of 1 crore to access a lot of databases. The government and the Bar Council needs to make databases accessible to a large number. So I think there's content accessibility, there is accessibility to technology, and there is a need to underpin the normal running costs of a university. And all of that is part of access. And as I see it, the courts have to interpret private and public education and some modicum of funding in a non-discriminatory way and in a way that really makes sense. Because if we do not bring in the breath of fresh air of all kinds of people into our legal profession and our court system, we are in danger of completely catering to a very small group. So I think that that's a great onus. And I think that the law school and the consortiums and all of these are up and fit for that task.
Thank you very much, ma'am, for that. There's a very interesting question from Philip Christopher, and I'm going to take that to Professor Vijay Kumar. The question is, should broadband be made a fundamental right?
Yeah, I think it's easy to say that you have to make it, but who will do it? Right?
As a constitutional law professor, why don't you take a shot at it?
Yeah, because the freedom of speech and expression is there. This is one mode through which people could access it. So it should be made as a fundamental right. There is no question, second argument on that. But the process is very difficult. It's very easy to say. Technologically, I think in the last decade or so, we have improved drastically from what we used to have as internet in 1988 or 89 to what you call it as today. I think there is a wide variation and wide improvement that has taken place, but still it is not without any problem. The problems are too many. Now, a couple of things which I would like to mention apart from using this as a fundamental right. I would like to just flag a couple of issues which I wanted. I raised my finger a couple of times. The law school Bangalore has the credit of starting what you call it as online ADR. And that has picked up a little. I think we have to learn lessons from the online ADR so that it reaches out to the people, so that the court system is not the only way. So we need to weave around that. And the second one is that the law schools have come together to create a platform called as the Legal Information Institute of India, which provides the legal databases of almost all the countries, including that of India. And I think these are the small contributions made generally to the 1600 law schools, in this country. But apart from this, I think there is a lot more things that we need to do. And I sincerely believe that broadband can certainly be made as a fundamental right. But I don't know whether the state will have the funds and the ability to provide this. And otherwise, there is no point in simply making something as fundamental right, which is not accessible by everyone.
Thank you very much, sir, for that. A question to Professor Poonam Saxena. This is from Abhilasha. Abhilasha is asking that if universities decide to move to online classes in the next term, how can courses that contain a practical element, for example, mock trials, moot courts, legal aid work, and other types of things which require an experiential learning component, how can they ever be transferred into an online context?
Not to the complete extent, but to a large extent we can do it. For example, the legal aid clinics have been receiving the petitions or the problems of the villagers here at NLU Jodhpur, even on computers. And since law students cannot actually appear in the court but can provide legal services other than appearance in the court, they have been providing it online as well. They were doing it both ways. There are several activities that legal aid committee members undertake. Some of them are not possible to take, some of them are not possible to do online in an online mode. That is very sure, and we accept that. Similarly, moot court. Now, recently we have seen that the international moot courts are also happening online. Recently they have had it. So moot courts can be done online, but there is no substitute. This is not a substitute to what we used to do ordinarily, but this is simply a viable alternative. So all these courses that do require a practical component can be achieved to a large extent, not completely, to a large extent, they are compromised, or to a large extent in online mode as well.
Thank you very much, ma'am, for that. Sudhir, there is a question which talks about to what extent law schools can persuade, let's say, potential employers and people who are, providing opportunities for students to keep up those promises or those offers that have been made. There's a lot of concern surrounding young people, particularly law students, that they had planned certain things to happen in the near future, and that is now, questioned and challenged. Can law schools do something about it?
So this is the way I think about it. I mean, we could have a practical response, which is about what is the law of contract on enforcing offers, that could be a practical response. But I know that the most structured response is to say, where is the market going and what are we doing about it? And my intuition here is that this digital push is not just about doing what we do. And I think Professor Saxena is already reflecting on that. It's not about just doing a clinic with Zoom, right? What it's really calling on us to do is to reinvent and transform our pedagogy and transform the way we interact. And for me, this is a huge opportunity. I don't see it as a threat at all. The trial advocacy class that we continue doing at the moment for the 5th year batch has gone rather well. I would go far enough to say that sometimes it might be better than what we did in person. And so I think there's a great opportunity here. And if we transform like this well, if we can get our students to both work in a structured way, despite distance, using digital technologies, then our students are going to be at the cutting edge of the transformation of the world of work. They will be among the most sought after because they have already adapted to the future of work. Right? And I think Professor Shankaran mentioned this. And for me, this is very serious. And this is very serious for the courts as well. This is not an opportunity to simply plug in Zoom and a learning management system. This is an opportunity to transform the way we work, right? It's a re-engineering opportunity. We should embrace it. If we embrace it in the law schools, I think that the legal profession will respond well to that. And I think the courts will have to follow, hopefully in a faster the better.
Thank you so much, Sudhir, for that. Let me quickly move to Professor Ranbir Singh. Sir, there are a number of questions that are talking in terms of the challenge of faculty in law schools. I think these are probably law professors and people who are in legal academia who are asking these questions. And they are asking to what extent the inability of many of our universities to attract bright people to come into academia is impacting both legal education and research that ought to be emanating from law schools.
Yeah, I have to agree, but that things have changed, but still we do not have best of people coming to the legal profession, or for that reason, more importantly, to teaching. And the difficulty is, apart from some institutions which are public institutions, the other institutions which are there in India, there is an open secret that they do not offer UGC grades or do not come to those standards set by UGC. So in that light, it becomes very difficult for a young person to think of teaching. And probably unless and until the nation is sensitized to the fact that it is a very important activity, education cannot be neglected, and they have to be paid well. Unless and until you do that, you cannot attract best of people to teaching. That is a certain thing to carry on.
Thank you very much, sir. There are a number of questions focusing on one aspect, and I'm paraphrasing it. This is to Kamala Shankaran, Professor. Neha and Shreyansh and Mithir and Piyush and Pranav. This is about the state of mental health in our law schools and universities. Is this the ugly secret of our law schools and universities, regardless of public or private. The state of mental health in our institutions is a matter of grave concern, and what should institutions do to respond to it more effectively, more transparently, more compassionately?
Thank you. And I think that that is a real concern. As you know, outside of our law schools, India has a very poor history of handling mental health. The stress people is, and more so on young people. And I think that instead of a command and control approach that normally one deals with matters of discipline, when you have young people staying on a residential campus, every avenue of communication between the administration and the student, between student and student is important. And it's going to become even more important in a digital era, because the irony is that you connect to the whole world, but at the same moment you get isolated yourself and become a monad, and it's you and your cell phone. And so you see both ends of the spectrum happening. Grades become very important, and in my experience, language skills are paramount in determining how well a student relates and how good the grades are. And therefore, the need for, apart from having an in-house counselor, which I know many of the good law schools have, but digital counseling, the need to also pay attention to the soft skills that are assumed every student should have. And I go back to the point about language. Language is a great divide that happens in India. And because legal education and because the language of the courts, because for constitutional reasons, is English, the need to have English is also a source of great trauma. And then, of course, all various other issues are there. It's better that the private secret is made public and it is addressed openly. And I think I'd like to nuance mental trauma a little more. The mental trauma is not only because of academic scores, it arises out of casteist slurs that are there, which are practiced sometimes by teachers or by fellow students, by sexist slurs, racist slurs. And therefore, I think it's very, very important to be alert to these things and to also constantly address and understand the fact that caste discrimination is a way of life for many in India, and it's experienced, and also sex discrimination. And I think in its digital format, it's even more difficult. So I think that we are alive to it. But on the positive note, because we are all alive to it, I think students must also appreciate that many of the law schools have put in place various structures. And therefore, there is also the culture of freedom and the right to speak up, which I think is the only effective antidote against these things.
Thank you very much, ma'am, for that comprehensive set of remarks. Professor Vijay Kumar, there are a number of questions that are, I think, something which you can answer this probably better than many. This is regarding the Bar Council of India. Astitav, Satish, Dimi, Syed, Jayashri, many are asking about to what extent India, they mentioned about the US experience of having what is known as a AALS, Association of American Law Schools, where all law schools are working under one umbrella. While the regulatory aspect of the Bar Council of India is clearly unchallenged in the sense that they do regulate legal education, legal profession, what is the scope for law schools, regardless of their character, public, private, state, national, all of them coming together and in many ways contributing towards shaping the future of legal education?
Yeah, I don't know whether to say anything about the Bar Council of India and what the law schools should be doing. But I think the law school got represented in the Bar Council, that legal education committee, but it is like hide and seek. Depending upon the circumstances, they call ex-Vice-Chancellor for a particular meeting, and second meeting, the Vice-Chancellor is missing, the next Vice-Chancellor is called, and therefore lots of discussions that have taken place possibly have not come into reality. And even when certain decisions are taken, put up on the Bar Council of India website, I think it is more than 2 years or 2.5 years, nothing got translated. And I've been speaking about this openly with the Chairman Bar Council of India. And wherever I meet, he says that yes, we should do, but nothing has been concretely done. Now, apart from that, whether the law school should come together, I think after this meeting is over, we have been talking about this for a long time. We have taken the first step of bringing the consortium of the law schools alone. My intention is to bring a consortium of all the law colleges under one umbrella, not simply the Teachers Association, so that whatever little we do, whatever benefits that we have, whatever little merits that each and every institution has, possibly can be shared with each and everyone in this country, even without the help of those institutions. I am very confident it can reach the students because technology has reached them, but there is a gap between the institution and these individuals. I think the Bar Council has to change its mode of operation, and we also need to blame ourselves because we are not able to do many things. But put together, if there is a body created like this in the years to come, I think we can serve the community better. And
Thank you very much, sir, for your, again, very candid and very thoughtful remarks. Professor Poonam Saxena, there are a number of questions that are focusing on issue of interdisciplinarity. I mean, one of the challenges of, I mean, since you've worked in a more traditional university and now working in the National Law University, one of the big challenges of single discipline institutions such as the National Law Schools or even the IIMs and others is that there is overwhelming focus on law. And the question is, to what extent these institutions need to do more towards having a stronger imagination for, you know, liberal arts and humanities and social sciences while studying law?
Professor Rajkumar, right now the focus is that whatever are the subjects that help students understand legal education in a better perspective, they are used as support subjects. For example, we have BA LLB honors and then BBA LLB honors. So those students who want to understand, students who want to take humanities, they go for BA LLB honors, and those who are in the commercial, you know, with the commercial background or the commerce background, they go for BBA LLB honors. Then these are also called the support subjects that help the students to understand the legal subjects in a better manner. So while we do offer BA LLB honors and BBA LLB honors with this emphasis on the arts, social sciences, and the corporate, but in traditional universities, we have just law papers because the students come from different disciplines altogether. Interdisciplinary approach is there, but it is not as rigorous as is in cases where students after graduation take the law courses. I would, Rajkumar, I would also like to go back to the question that was posed to Kamla, because it has been bothering virtually all vice chancellors and law schools about the mental health aspect of the students. Can I?
Please, ma'am. Go ahead, ma'am.
What I have found is that the students in this particular age group, they have their own challenges. And most of the law universities, therefore, have appointed a student counselor to whom they can approach and share their problems. But my experience has been that students do need an outlet to express themselves, to seek guidance, but they are very, very hesitant to approach a teacher who is teaching them a subject. They would not like to confide in a person who is known to them and known to the other students also. So what our experience has been to have a professional counselor coming from outside, and then students confide in them, and then definitely they are, what to say, happy, not happier, but satisfied when they approach a professional counselor who is totally unknown to them and also unknown to the fellow students, because many a times the students have problems with students themselves, and they would not like to talk to the teacher. That is one of the aspects I just wanted to share with you.
Thank you very much, ma'am. I'm feverishly trying to gather these 250 plus questions and selectively put it across to all of you. Pardon me for this coordination. Sudhir, there's a question about the state of PhD studies in law schools. You know, when I was a student in law faculty, Delhi University Campus Law Center in the 90s, I always found the PhD program, even in Delhi University that time, it's just in the margins. They're just out there, so much not at all in the mainstream. And many years later, I observed that trend in many other law schools as well. At one level, law schools are struggling to find the most outstanding people to become academics. At another level, we also see a trend where PhD programs across law schools, without naming any institution, are pretty much relatively mediocre and mostly in the margins. Is it time for us to resurrect the law school PhD program?
Thanks, Raj. It's a timely question for me, and I'll just say a little bit why, and an important question for all of us. So the ironic feature of the Indian NLU experiment has been that the lower the degree, the tougher it is to graduate. Right? So when you do the BA LLB or BSc LLB, you go through a rigorous program. Somehow LLM students always pass, though we might have a fail rate in the first degree. Second degree somehow gets easier. Now, if you go on to do further degrees, an MPhil or a PhD, somehow that's even easier. And if you, God forbid, want to do a double doctorate or something, you know, a D.Lit seems to be the easiest degree to get. And there's something astonishing going on in Indian legal education, and more generally in Indian education. I think this is true for the traditional universities as well. And this has got to stop. And let me be blunt about this. This just cannot go on. And whoever is responsible and whatever historical factors are responsible for this, so be it, this has got to stop. And I can tell you that in 2019-20 at NLS, we have slowed down the PhD program. We have scaled back a huge amount. We have just completed, I joined very late in the academic year, and we hadn't advertised. We have now advertised and we have selected, and you'll see when we announce these names that this is a different cohort of PhD students. And we have promised all of them funding. All of them will be funded by NLS through their PhD years through the years. And we have a different approach now to this. It's not about scale, it's about doing quality. We have a long way to go. Let me say that clearly. We need to have more rigorous coursework, and we need to have very clear pathways on supervision and assuring the qualities of work, so that a PhD in an Indian university is as good as, ironic that your own chosen university abroad to do a PhD in Indian law, you know, and that's got to change. And I hope that in the next few years we'd be able to change it. Can I just say one last line? So the COVID-19 pandemic is very interesting. I think it affects British and American universities more, and Australian universities more than it affects us. And so I really invite all those students who were thinking that they might want to do an LLM here or there around the world, which are all good things to do. But given the circumstances that we find ourselves in, try us. And if we are able to up our own standards and do these PhD and LLM programs, we will change, using this crisis, what the Indian LLM and what the Indian PhD means. Thanks.
Thank you very much, Sudhir, for that. Sir, Professor Ranbir Singh, there is a question which is connected to what Sudhir just, towards the last part of what he said, is about internationalization and student mobility. A lot of your students, I'm sure, but students across the Vice-Chancellors who are sitting here, they have secured admission to universities abroad this year. And we came to know just now today that Cambridge is entire online, and many universities are creating different types of methods. We need to provide, a lot of students are asking about advice. Should they be going abroad at all? And of course, by way of full and complete disclosure, I have said to my own students that for the next couple of years, world is not well suited to receive international students, regardless of whichever country you're coming from. So Professor Ranbir Singh, what would you like to tell to the students?
I fully agree with you, Rajkumar, in spite of the fact that whatever admission you get in any good institution, this is not the time to travel abroad. And I certainly agree with you. This is not going to happen for the next 2 to 3 years. I think there is a waiting period for this kind of activity for at least 3 years. And there are good institutions in the country, and probably they can explore those possibilities of taking admissions within the country itself. Probably, I agree with you.
Thank you very much, sir. Well, I want to tell you that there are lots of students from your own universities asking questions about schedules and things like that. I'm ignoring those questions. I'm picking up selective questions. Professor Kamala Shankaran, there's a question about the very definition of workplace. I mean, in this context of online education, you talked about cyber, bullying and things like that. Do we need to redefine sexual harassment in its entirety, where the possibility of online type engagement can lead to a significant redefinition of what constitutes a workplace? One of the questions has come from Aniket.
Yeah, thank you. That's a great question. And for sure, our classrooms are now both a physical space and a digital space. So anything that happens in the classroom, as I was talking, the teacher also needs to reconsider her role, not just as somebody who is stimulating the students mentally or giving but also as an umpire in the way discourse is happening in the class. And that class space is also not confined only to a Zoom lecture. There are a whole, for example, I took the example of Google Suite and the responses that are given. And yes, that constitutes the educational workspace. And you see the same thing happening even in the normal world of work. That the world of work, which has moved to digital platforms, and if you look at the gig economy, that is also a site of potential harassment and discrimination. And of course, because we have a common law system, we're waiting for the courts to put its imprimatur on it and to say, yes, it is so. But I think all of us understand very clearly that the workplace is now straddling the entire the digital world. And which is why, if you ask me, even comments, uncurated comments that come up and trolling that happens has to be seen as part of workplace harassment. And we know that in many places, domestic violence at home has also been considered as harassment at the workplace. That because of harassment at home, you are facing the consequences of it here. So I think in ever so many ways, the boundaries, hard boundaries between public and private are evaporating. Hard boundaries between classroom and outside are evaporating, and which goes to show that the teacher of today and tomorrow needs to be 24/7 thinking all the time. And I think that's happening because the amount of effort one puts in to do an online class and the kinds of material one collates, the delivery of it, the frequency with which students, so the work hours idea is also going away. How we protect our privacy, of course, continues to be a key question, but in pointed reply to that question, the answer is certainly yes.
Thank you very much, ma'am. So this question is for Professor Vijay Kumar. A number of questions have come about, and a very serious matter which has battled me personally also in relation to online education. The question is, of course, is from Abhilasha, who's asking, how can universities address academic concerns of copyright violations with regard to course materials, given classes are recorded and streamlined? But a related aspect is, for many of us who work in the field of constitutional law, human rights, issues that, let's say, question state power, there is an autonomy of the classroom experience that we're used to, where whatever we say and engage with students remain pretty protected in that sense. The online framework, for very good reasons, expects recording so that those students who don't have access to that experience live can go back. then the question is, to what extent this creates a very awkward sense of even potentially a self-censorship, a restraint on the part of both faculty and students when it comes to discussing difficult issues.
Yeah, I fully agree with you because within the four walls of the classroom, the teacher becomes the boss. The teacher can say whatever he or she wanted at a particular point of time. But I think as the technology comes in, slowly the teacher has to learn what comment one can utter openly and what one should not. Having said that, whether it is recording mandatory, I would like to differ from you because you can also have an online class or a course where recording is not permitted, number one. Number two, even if recording is permitted, it is only for limited audience, only for that audience, and no one else can take it. So therefore, there are certain boundaries within which one can easily play, but certainly it will change the way that the teachers would like to comment freely, without any hesitation within the four walls of the classroom, to what can happen on an online platform.
So what the problem is not so much whether what we can tell, but today what has happened is people can, even if you don't permit recording, people who are watching it can, like this program we are having, people who are watching it can record it in a smartphone wherever. So that degree of freedom has, that's what it does. And I take your point that that's one of the sort of fault lines that we need to deal with. Professor Poonam Saxena, this is a question with regard to, several students, it's particularly a student-related issue, which is about the fact that this particular situation, we all say, is a temporary situation. We will, get over it. Are there long-term implications that institutions need to be concerned about? In the sense that as much as we feel this will be over within a time period, are there things that will have a longitudinal impact on the life of a student who is going to pursue legal education? Several students have raised this question.
As I said before also, and as everybody knows, that these are difficult times and unprecedented situations that we find ourselves in. And we would also like to share our experience as far as the long-term implications or the expectations of the student when they join law schools are. Because at the time of the counseling, many of the students, when you ask them, why do you want to join law? They will come up with several answers like, we want to serve the society, many of them. And at the same time, there is also an expectation that since they are joining a law school, they will if they do so want, they will have good placements. Now, the situation as it exists right now, the fourth year and the fifth year will be affected. And will be affected adversely to some extent, because the fifth years, those who have job, they are uncertain about their date of joining. The fourth years, they have yet to sit in for day zero, and they are not sure about how the placements are going to be affected. So definitely, at least for 2 years, if not in a longer time period, they are going to be affected at all. They are going to be affected. But I still hope, and I have a feeling within myself that the things are definitely going to improve. Maybe in 6 months or 1 year, and legal profession is such that is not going to see recession at all. And therefore, the students who aspire to pursue legal education should not be worried about it. The situation will definitely improve. It is purely temporary, and when things will improve, they will improve very fast. And I would also like to, having said that, I would also like to add to what Professor Vijay Kumar has said about, I, for example, will be very uncomfortable if my lectures are recorded and they are put in public domain, because when you are a teacher, you are in a class where you want to give your best and make the class interesting as well. So sometimes you even end up cutting jokes or making a light remark, which you definitely would never ever want to be recorded. So this is one of the things, Professor Vijay Kumar, you must have also experienced the same. Because when we are in a class, we are not merely a teacher, we are a friend to them. Sometimes we pose a problem, we take a contemporary example, which we would not like to be recorded at all. That's my comment on that.
Well, thank you so much, ma'am. And I think it's a very big dilemma, simply because of the fact that Today, we have already gone into a world where whatever we say or do in any technological platforms and spaces, we should assume it is indeed being recorded in some way. And that's the biggest challenge that is posing to privacy and civil liberties. Sudhir, one of the things that we are dealing with is that given the fact that there is still the blended learning idea, there are lots of law schools around the world who have embraced online full-fledged master's degree programs. There are online LLMs and good law schools in the world. We, of course, are even struggling with the first phase of online. We talked about it. Do you think that's going to be the future? That today, this COVID-19 crisis will push us towards a scenario whereby what Coursera and Baiju and Khan Academy and other types of platforms have been doing for years together, is this going to be the new normal where law schools will embrace the idea of online master's programs in particular?
So that's some future gazing, and it's tough to predict. So I wouldn't hold this out as a prediction. The way I see this space is that there will be the place of the intimate classroom where teacher and student in the same room, and small classrooms, medium-sized, large classrooms will remain. It's not going to go away. So I think that those and the intensity and both the meaning of that exchange will remain. I don't see education as such moving away from that completely. And higher education is not going to go that way either. I'd just say two things, and this is broadly how I've seen it, and I'm thinking about it at the National Law School. The first is that we will offer education across the spectrum of an on-campus and off-campus experience. This is going to become standard. We currently have on-campus programs which we think are our premium programs, and then we may have some off-campus or may not have some off-campus. I think all programs are going to be partly on-campus and off-campus going forward. The programs that are highly curated and highly wanted, sought after, will be our on-campus programs, and they will also be relatively highly priced. Whereas the programs that are offered, and I'm going to sound a discordant note to what Professor Vijay Kumar and Professor Saxena said, that I think we have to assume that all our materials are public, and they are, content is going to be free, and it's going to be ubiquitous. It's going to be everywhere. We can play some role in trying to control that content. But it's not going to be the case, really. So I see that happening. The second thing I'd just say, and I'll say it very quickly, Raj, is that I suppose that Professor Shankaran put it very well, that we are going to see unconventional ladders of learning. So the Baijus and the Khan Academies are probably ahead of us in that they understand this. People are going to learn at different speeds, in different stages, using different pathways. We have to prepare for this. This is where it's going to go. This old neat cohorting of first year, second year, third year, so on. I don't know. Maybe it will last for a decade, maybe a decade and a half. I don't know. But we are going to have to embrace quite a dynamic space of learning where material is available, interaction is premium, but people are able to navigate that space in myriad ways that we cannot imagine at this point.
Well, thank you very much. We are going to move to the last question that I have for each one of you. And it's been a fascinating discussion, and I still couldn't take up many questions. So let's start with Professor Ranbir Singh. This question is, for those students of law who are watching this program, what would you like to tell them as they experience this crisis with regard to their studies in law school, possibly their future? How do we give them hope about the future of legal profession in times of this uncertainty?
I think one important thing I need to impress upon is that we all combined should put more and more emphasis on and create platforms for MOOC programs. And some programs can be free, some programs can be paid. And if, for example, we started about a dozen MOOC programs, and we have about 15,000 registrations. And because all these programs are free. So let us all law schools and institutions, those who are interested, join hands and create more and more MOOC programs for the students, and it can be free. And it will also be a solution to where you say that the faculty is not available. And these MOOC programs are like a diploma programs and also be a supplemental to the lectures. That is one program. Second thing I would like to share with all my panel friends would be we need to change the system of examination. The system of examination which we have, the midterm and the final semester kind of thing, probably we need to go for a continuous evaluation of students now. The COVID-19 have shown us that those systems are not going to work in future. So the system of examination has to change. Third, Rajkumar, a suggestion for you. Whatever discussion we had today, probably I will believe that we share this discussion with other law schools and friends and prepare a document, and so that we can share whatever we have said and supplement it with the feedback which we get from other people. It was a wonderful discussion. Thank you for doing it very well, and you anchored it very, very nicely and giving full opportunity to everybody. Thank you very much, Rajkumar.
Thank you, sir. Professor Kamala Shankaran, the same question to all of you. Ma'am, you need to unmute yourself. Unmute yourself.
Yes, thank you. I'm unmuted. Yes, legal education is broadening greatly, and I think we must also, aspect we've not talked about this evening is the continuing legal education for lawyers also, because the world is changing so fast. So we need to address that, and I think law universities and law academies and law faculties are also a good place for that to happen. I wanted to add that. I think students and potential students who are watching this, or current students or lawyers who are watching this, it's very, very important that we see and continue to see law as an instrument of social change. That sense of hope and optimism must be there, coupled with a deep and profound belief in the rule of law, is the actual wellspring of optimism that will be created in the legal profession and in the legal system and the courts as a whole. And I think that we must engender that and deepen it greatly. Third, I agree with many of the points that many of my colleagues here have said, and I think I'll stop here.
Thank you so much, ma'am. Professor Vijay Kumar.
Yeah, I think I am very optimistic. I would like to inform the students who would like to become part of the law schools, private or public, that you are most welcome. This is a wonderful, challenging opportunity for you ahead, because it's not a one-year course. It's going to be a 5-year course or a 3-year course. And I think it's a great learning ahead of us. And the role of a lawyer will change. The role of a judge will change. The role of the students will also change. As technology comes in, as social changes are also coming into picture, I think you will face the challenges, and the law students will get into different types of avocation, which is not purely the courtroom based. And therefore, you are most welcome to take the challenges and guide the legal profession in the future. Thank you.
Thank you very much. Please, Professor Poonam Saxena.
Yeah, I would like to reiterate that legal education is a very coveted option for the students, and they must opt for it. They should opt for it if they so desire. This kind of a situation that we are placed in has thrown new challenges and also have given new opportunities, because a homogeneous mix of this technology and the classroom teaching definitely is going to change the scenario as far as the legal education is concerned in coming times. So we'll see a better blend of education. We'll learn from this kind of challenge and the opportunity that has thrown in. We have learned the value of technology here, and we will also know how to best use this technology for the betterment of legal education. So it remains a coveted option. It will definitely go through several options for you for employment as well, if you so want.
Thank you very much, ma'am. Sudhir.
Yeah, thanks, Raj. So when we were in law school, Raj, and we were roughly graduating at the same time in the 90s, in the late 90s, I think most of us felt that the quality of education or the level at which we were educated and the resources we had access to had a lag to where education was in the rest of the world. And I think that some of the people on this panel and others who are not on this panel, the universities in India, the NLUs, have shown that we are just about where any other university anywhere else in the world is in responding to this crisis. And I am very proud of my students and of my faculty for the fact that we have delivered almost a glitch-free learning experience to the extent that we can in response to this pandemic. And I would hazard to say that 30 years ago, Indian institutions were not there. And so I'm very excited at that outcome and that possibility. The second thing I want to say is that, you know, this transformation that might be slightly forced and we haven't chosen it, its timing or its method, is a very important transformation. I would say current students, future students, we should embrace it. I think students who have just graduated 3 or 5 years before you will be envious of you for having this experience and this ability to work in this disaggregated, decentralized, digitalized way. These are skills that will matter greatly in the years to come. And here is this great opportunity to go in there and learn it. I want to say one last thing that you know, this Professor Ranbir Singh spoke about MOOCs. I think MOOCs are important. And at NLS, we are working very, very hard to make sure that we offer a completely reworked model of online education starting in July. And July 2020, I would say that, look, we will educate much more widely than we have for 30 years in many multiples of what we have done so far. And so the opportunities that law students would have, irrespective of which university they are enrolled at, that doesn't really matter. These opportunities will become available and they should grab them and make the most of it in the years to come. So that kind of democratization of education, which is going to happen in the next 2 or 3 years in a rapid way. It's not going to happen slowly. It's going to happen so quickly that many of us are going to say, is this really what education is going to be like? And I think that we are well placed to respond to that. And for students, this is a really dynamic, exciting time.
Thank you very much. I'm really grateful to all of you. I want to end this program by a tribute to Professor Madhava Menon, who is no longer with us, but all of us have been deeply affected, impacted, inspired by his life and the discussion that we're having, representing mostly the National Law School, but also our own institution. All of us have been inspired by his life and his contributions. So I want to pay that tribute to him. I want to thank each one of you for your candor, for your commitment, for your dedication, for your time, and the extraordinary work that you're doing in indeed difficult circumstances. So thank you to each one of you for sparing the time. And third, to also thank all the viewers who participated in this. I'm sorry that I couldn't take as many questions that I wanted to, but thank you for being there. And lastly, an announcement. We continue to have these programs twice a week. Next week, we are having on this Saturday a Global Lawyers Colloquium on the theme Diversity in the Legal Profession and Judiciary. What's the hope for the future? I'll be joined by Dr. Menaka Guruswamy, Senior Advocate, Supreme Court of India, Ms. Pratibha Jain, Partner and Head, Nishit Desai Associates of the New Delhi office, Mr. Tanveer Ahmad Mir, Advocate and Founder Partner, Lex Alliance, New Delhi, Ms. Tejal Patil, General Counsel, GE India, and Ms. Pallavi Mehta Wahi, Co-US Managing Partner of KNL Gates, Seattle. We look forward to seeing you at 6:30 p.m. on Saturday. And with those words, I would like to once again thank my distinguished panelists here, some of whom have been my mentors. Sudhir and I go back to our Oxford days. We were together, and it's a wonderful experience to have this conversation with all of you. Thank you.
Thank you, Raj.